Okay, we are, let me just make sure it's populated. Yes.
Are we ready now?
We are ready. Yes,
Good
ma'am.
afternoon. I would like to call the policy committee to order and welcome to each of you. Our agenda, the next item on the agenda would be to approve the minutes from our last meeting. Are there any corrections to the meeting minutes that were sent to you? If not, the minutes will stand approved as presented. At this time, I would like to call the roll so that we will have the quorum identified in the minutes. Lane Dunton.
Here.
Reggie Silver, not here. Dean Edwards, is not here. Sharonda Bullock Thomas.
Here.
Sharonda Thomas Bullock. Sorry about that, Sharonda.
That's okay. That's okay.
So we have 3 of the 5 members here. We have a quorum, so we can proceed with the meeting. With that, I'll turn it over to Dr. Catalano.
Good afternoon. All of the policies that we have for you today are from the North Carolina School Board Association. There were 10 policies that had changes to the body of the policy, and then several that were minor technical changes to the policy. So we're going to start with the substantive changes. With policy 1710, 4020, 7230, discrimination and harassment prohibited by federal law. You should have in the materials that I shared prior to the meeting, you should have the custom policy update memo as well from the School Board Association. And the description of these changes is on the first change on page 1. We did have someone join us just a moment ago. Mr. Edwards, is that you?
He said, yes, it was. I just got a text from Dr. Calvin on it.
It says iPhone, so I'm going to rename that to Dean Edwards.
Chair Bullock.
Yes, sir. Mr. Edwards?
Can anybody hear me?
Yeah.
Yes, Chair.
I can hear you.
Can you hear me?
Yes.
Okay, I just making sure you knew I was here now. I was going through a bad spot in the world.
Oh, we don't have such places.
It's a pure hole in the earth over there.
Thank you for joining us.
Okay, so
Yes, ma'am. Sorry about that. But I'm good now.
Good.
the first policy that we have is discrimination and harassment prohibited by federal law. Mr. Farrow was not able to join us today, so I'm just going to quickly go through these changes with you. Section D1 included Let me pull up the policy here. Actually, I apologize. Section F had a strikeout in it, revising it to remove the implication that the discipline of a person who makes a false statement would constitute retaliation or reprisal. And this was per OCR feedback. And this same change was also made in the next policy we're going to be looking at as well. So the change pulled that out and replaced it with an individual who makes a good faith report of discrimination or harassment. So no reprisals for a good faith report as opposed to knowingly providing false information. Are there any questions about that?
Are there questions or comments on that policy?
No, ma'am.
Then we'll go to the next one then.
Okay, and the next one is the same change. Ms. Wallace, do we have you on the call? Would you like to talk through that one? Sure why it didn't show up in color here, but this is the, oh, it didn't. Just didn't wait long enough.
So we're going to 7232.
I apologize. Yes, we are. 7232, which is discrimination and harassment in the workplace.
Are there questions? If not,
Ma'am.
next I'm sorry.
No questions.
No, ma'am.
Next policy. Was that somebody else saying something? Then we'll go to the next policy, Chris.
The next policy is policy 1750, grievance procedures for employees. Ms. Wallace, would you like to kind of highlight those changes?
Okay, good afternoon, everyone. There have been minor changes to this policy. If we scroll down to the second page, they are removing a sentence that talks about the claims of discrimination, harassment, or bullying must be processed under the policy 1720, 4015, 7225, discrimination, harassment, and bullying complaint procedures. That will be removed from the policy. The next item that will be removed is 5. Speaking of the official is the person hearing and responding to the grievance. And if we scroll down to the part C, talks about timeliness of process, and they are adding failure by and they're adding failure by a school system official. Also, they are including in this policy the paragraph beneath that one has notified the appropriate school system official. You scroll down to part D, general requirements. Number 1, they are including at all times during the grievance policy, all must, and then they are removing a sentence in my grievance field pursuant to this policy shall, but they must conduct themselves in a professional manner, including respecting the confidentiality of personnel matters. Then they remove the next line at all times during investigation and hearing of the grievance. Coming down to number 5, They are removing school system and adding administration. And they also recommend that we remove the board and officials. On number 6, they are removing employee and including grievance. Again, removing employee and including grievance. For 6 and 7, it's highlighted within 3 days, the appropriate school amount of time that they have to report. But we're not sure if 3 days is sufficient or if that's an area for discussion, or we just want to leave it as is. And let's scroll down. Go ahead.
I'm sorry, go ahead.
Scroll down to part C. Again, we're removing grievance and including employees. And then we're also adding any grievance against the superintendent should be filed directly with the board in accordance with subsection E.4 below. You come down to part 2C. They're including the official shall meet with the grievance, and removing a meeting will take place. Part E, they're removing a aggrieved employee and including grievance. 3, part B, removing employee, including grievance. The same for C, removing aggrieved employees, adding grievance, and with the grievance. Nope. Come down to F, records. They're removing shall and including will. They removed all of the prohibition and discrimination, harassments, and bully complaints procedures and the policy numbers. And I think that's it for that particular policy.
And just as a reminder, the reason that they removed those cross-reference policies is that those were rescinded in our last, actually, I think 2 meetings ago, but this update, or the previous update, included Title IX changes, and several of the policies name and numbers changed as well. So those are not existing policies anymore. That's why they were removed.
Okay. Now, going back to D7, I think it is, with the 3 days right there. What is the recommendation of the administration, whether it's 3 days or in advance or any other time period?
3 days is what has been recommended and what we have traditionally done. But it's really our decision if we want to allow it to remain at 3 days, or if you want to do a shorter time period or extend that.
Okay, in the notes section on the policy on the updates, the question is asked if we leave the 3 days, do we need to identify 3 days from when, or 3 days before when?
So am I reading this right? And it's not when they're notifying us, it's just that they're notifying us that they're having representation as part of their grievance?
That's correct.
That's correct.
So they can notify us of the grievance, and then down the road, they would need to let us know within 3 days of bringing counsel on that they were intending to do that.
But within what, 3 days? 3 days before? Because in the notes, they say that we might need to add additional information to identify the time period, 3 days from before the event, whatever. So 3 days, it seems, would be a little bit unclear. So if we're gonna use 3 days, then we need to put 3 days before the hearing. Is that what we're saying?
Or is it 3 days
Madam
from when
Chair.
they engage an attorney?
If I may, I think in other policies that have similar provisions,
Mhm.
typically it's 3 days prior to a meeting or a hearing. And so it seems to me like I think the intent here would be prior to any meeting or hearing, because the intention is to allow the board to obtain legal representation for itself at presumably that meeting or hearing. So I suspect that that's what the intention is, at least based on other policies that have similar language.
Mhm.
So I would say probably within 3 days of any meeting or hearing under this policy.
That's fine with me. That specifies what we're actually talking about. Lank, Sharonda, Dean, what are your thoughts?
I would agree. Being specific would be helpful. I guess you can kind of read more or less into it if it's not specific. So I would agree with that.
I'm good with that time period of letting us know 3 days prior to meeting.
Dean?
Yes, ma'am. I'm the same. I think it needs a little bit better wording for clarity purposes.
Okay. So Chris, did you get that to add 3 days prior to, okay, you're putting it in now.
Also, Ms. Chair, I got one more recommendation.
Uh-huh.
Business or calendar days. I'm assuming business.
I don't know.
Lindsay?
What 3 days are we speaking of? Are they calendar days or business days?
It's all over the place depending on what policy or statute you're looking at. So it's up to you all whether you want to do, and sometimes it's not even calendar days. Sometimes policies say school days as well, because obviously, so I think it's up to you all what you want to put in there. But I think I agree that you probably want to be clear about that.
What's the feeling of the group? Do you want business days, calendar days, or school days?
My thought process would be business days.
I would say the same.
Lank, is that fine with you?
Yes, ma'am.
Okay. All right. I think that reads much clearer. Are there any other questions or comments or changes to this policy?
No,
How about
ma'am.
me?
All right, next policy then, Chris.
So the next policy we have is policy 1760, 7280, prohibition against retaliation. And Ms. Wallace, this actually addresses both employees and students. So Ms. Wallace, would you like to talk through the changes in this one as well?
Okay, this policy does speak about the grievance procedure for employees. If we come down to the second paragraph, they are adding and deleting some information there. Adding unless a policy with a more specific reporting or complaint procedure applies, and they are removing the policy number, discrimination, harassment, and bullying complaint procedure. They're also underneath the cross references, removing that policy involving discrimination, harassment, and bullying complaint procedures. They are including discrimination and harassment prohibited by federal law, policy 1710, 4020, 7230, Title Non-Sexual Harassment, Prohibited Conduct and Reporting Process, Policy 1725, 4035, 7236, Title IX Sexual Harassment Grievance Process, Policy 1726, 4036, 7237, Non-Discrimination on the Basis of Disabilities, Policy 1730, 4022, 7231. They're also adding Policy 9100, Discrimination and Harassment in the Workplace, Policy 7232.
Are there questions?
No, ma'am.
Next policy then.
Okay, our next policy is 1740, 4010, students. And this is one that is both students. I apologize. That last one was just employees. Student and parent grievance procedures. I'm going to talk through these. So these have similar changes related to those policy updates around Title IX. So the reference to the old discrimination, harassment, and bullying policy was removed. Similar to the previous policy that Sheila talked about, where it removed the definition of official, added the definition of parent to specify that it includes a parent, legal guardian, legal custodian, or another caregiver authorized to enroll a student under our domicile residence policy. And clarified who the official is, so a school system official. And I think that was, and then added here that the grievant could have representation, including an attorney, at any meeting or hearing during the grievance process. The student grievant may be accompanied by a parent as well as a representative. Took out the word guardian because it had defined parent previously. And that's what all of those changes are. In section D and E, it just clarified that a student or parent could initiate the grievance procedure. Reference the meeting, took out parent or guardian and put grievance here. The same with this. Response by the principal. Took out the statement that the student could be accompanied by a parent or legal guardian because it was provided for in the prior section. I believe, yep, it's just removing the old policies and did add the domicile or residence policy reference at the end. Any questions?
Chris, can you scroll back up? I forgot where the page was, but I know it when I see it. It seems like it was kind of redundant where we added a sentence. Mm-hmm. Right there. Let's look at that. At any meeting or hearing during the student. The grievant may have a representative, including an attorney, at any stage of the grievance. At any meeting or hearing during the grievance process, a student grievant may be accompanied by a parent as well as a representative. Are they not saying the same thing?
I think the first two sentences are speaking specifically to attorneys. and legal representatives. And the last sentence is saying they can also have a parent or another representative with them as well. Lindsay, would that be your take on that as well?
Yeah, I think what they mean is that in addition to a representative, if they have an advocate or an attorney, they can also have their parent accompany them at any stage of the grieving. So it's sort of making sure that, you know, that they can have this additional person on their behalf in case their parent is not also their representative, if that makes sense.
Okay.
It's not the most elegantly drafted language.
It is not. It seems to be redundant, but it's okay.
I got a question.
Anybody else?
Madam
I'm sorry.
Chair,
Yes.
can you hear me? So my question is to the attorney. Is there a signed document that their parents have to sign or release for a waiver to have somebody representing them in this case?
If they have are you talking about that they would have that their attorney would have them sign, or that the school?
Well, I guess it's alluding to what Mrs. Bullock was talking about earlier, and I was hearing it, couldn't hear it, but having the parent having someone to represent the parent in case the parent's not there. Is there a document that the parents sign stating that such and such a person can represent them?
I see that the parent would give the attorney the ability to represent their decisions. I've not seen that typically, and I don't know that we would necessarily. And I need to go back and look at the language here, but you know, I don't think typically we would not allow the attorney to have the decision, to supplant the decision-making authority of the parent. So if an attorney is there representing the student and the parent isn't there, the attorney would just be speaking on behalf of the student. That's typically the way that we usually view those types of representations. The attorney would not have the ability to make educational, decisions on behalf of the student.
That's the sole right of the parent, correct?
I'm sorry?
That's the right of the parent, correct?
That's correct. That's correct. Yes, sir.
Or the legal guardian?
Yes, sir. That's correct.
Okay.
Mm-hmm.
Thank you.
You're welcome.
Miss Lindsay?
Lindsay Dean has a question.
Yes, sir.
Could there be age-specific problems with that, like 14 and under, 14 and above, or 15 and above?
I mean, I think that's a really good question. I mean, I think typically, obviously we would want the parent to be involved in those kinds of conversations. But usually, usually in these kinds of grievance processes, if they have an attorney, that attorney is simply, is making legal arguments on behalf of the student, not representing the student in terms of their educational decisions. And so, it's not necessarily, we wouldn't necessarily have a problem with the lawyer sort of being the mouthpiece for the parent in terms of educational, if that's what you're asking.
Kind of. I just, and I may be getting one of my previous jobs mixed up with this one just a little bit, but it just seems that there may be some age-specific things dealing with representation and the needing of representation, especially when you start talking about matters of law and grievance. That's all.
Yeah, and I mean, I think it's a good question. Excuse me. I think from an attorney perspective, normally an attorney is going to want to have some kind of parental involvement if they're representing younger students. But I think that's really a matter between the attorney and the student. And as long as the attorney is not being used to make educational decisions on behalf of the parent or on behalf of the student, then I don't know if it's something that you all need to be too concerned about.
Okay, I was just making sure that both our students and us as a board is protected, that's all.
Yeah, absolutely.
Are there other questions? Next policy.
The next policy is policy 1742, 5060, and this one is responding to complaints. And I'll just talk through this one, the changes in this one as well. So it did remove the reference to the rescinded policies, discrimination, harassment, and bullying complaint procedures. It added in the reference to all of those new policies that replaced that, which were the prohibited discrimination, harassment prohibited by federal law, the three Title IX policies, and then the bullying and harassing behavior prohibited, which were new policies that have already been adopted by the board. And then just updated that in the cross references as well.
Are there questions?
No, ma'am.
Ma'am,
Next policy.
I believe we have Ms. Griffin on the line. Robin Griffin is on the line for this next one. This is policy 3410, testing and assessment program.
Good afternoon. So this one is very straightforward. DPI and the Department for Career Technical Ed made some adjustments to their assessments in the CTE area. And so what you can see is that they have marked out post-assessments here. And now they will be using credentialing. Will you scroll down just a little bit, Chris? Thank you. So they will be using some credentialing and state assessments. And so basically what they have done is replace the word post-assessment with state assessment. In some cases, they're the very same assessments. Other times, there were new assessments that were designed in order to meet those requirements. So you can see here where they've marked out students have to earn a credential that is approved, that is no longer required with the new state assessments. And we actually were required to implement this with first semester testing. So actually it's already in place in the district state. Are there any questions?
Is someone trying to say? Did we miss something? Evidently not. Are there questions?
I couldn't tell either, Ms. Bullock, but so then the only other changes are some references to where some PDFs were being stored and some updated URLs.
Are there questions?
ma'am.
All right, next policy.
Thank you.
Thank you.
Okay, our next policy is policy 3620, extracurricular activities and student organizations. That one has disappeared.
Good afternoon. This is Angie, and I'm going to go over a few things with you as Dr. Catalano is pulling that up. The first page, you'll notice very few changes, just some strike throughs for some verbiage. No major changes there. You'll notice in the last sentence of section A, that has been moved to standalone section F. So I will get to that in just a moment. Throughout B, you'll see that they have some strike throughs, but as far as it relates to athletics and interscholastic athletics, we have no changes there. That is what is in place already. Section 2, so this is a recommendation that has been set forth. This will line up with our facility usage policy and our forms that we already have in place. All of this section 2 is new. It's what we've already got in place, as I said, but it's in reference to secondary schools and students that initiate non-curricular activities or meetings. It also talks about school employees not promoting or leading this, but it does say that school employees can be involved, but they can't lead or promote this, but there will be no funds exchanged for students that do these non-curriculum related groups. They get the same access as anyone else with our facility usage. And again, this would line right up with our forms that we have in place for rental fees. It would just be no fees involved if they're students. If you'll scroll down to the next section, C is the same as it was already. There are no other changes throughout until you get to F. And F is the section that was the initial section that we moved from the beginning A, where it's the appeals process, which is in reference to grievance, and we have that in place. The others are just strike throughs and updated websites.
Are there questions?
No, ma'am.
No, ma'am.
Next policy.
Thank you.
Thank you.
So our next policy is policy 4600, student fees. I believe we have Ms. Jarrett on the line for this one.
Good afternoon.
Good afternoon.
4,600 student fees. What is, we're adding, or we've been required to now publish a schedule of fees, charges, and any solicitations that have been approved by the board on our website. And that has to be published by October 15th of each school year. And whenever there are revisions, we just have to update that too. So, and then also add the principals of each school have to make sure to notify students and parents of the availability of the, or for requesting a fee waiver or a reduction. So it's just things that we have to adjust in what we've been doing in the past. We are currently creating that schedule of fees to be placed on our website within the month.
And the process for requesting a fee waiver will be added to our student parent handbook.
Other questions? If not, next policy.
Okay. The next policy is policy 5070, 7350, public records, retention, release, and disposition. And the only addition to this is this statement here. Any report received from the Teachers and State Employees Retirement System pursuant to General Statute 135-8 F2F is not a public record and will be treated as confidential.
And Chris, I can give a little bit of color on that.
Okay.
That has to do, you all may be aware of I'm sure you're aware of the pension cap statute under which, boards have been assessed and are being assessed for additional contributions to the retirement system based on the retirements of certain employees. Under that statute, there is a requirement that the retirement system provide a monthly report to the boards of education listing employees who might potentially trigger additional liability once they retire. And that report, that there's some pieces of that report that need to be reported to the Board of County Commissioners, but the report itself is not to be disclosed. And so there was an update to the law to make that clear that the report itself is supposed to be treated as confidential. It's not a public record. And so that's why that's added in there.
Just so that everyone knows, when we do get that report, and sometimes we don't get it monthly, to follow the policy, we give the actual report to Attorney Malone and Dr. Ellis, and they do share that with the board. And also a letter goes to the county commissioners, and the only requirement for that is we have to tell them the number that's listed, the number of individuals that's listed on the report. We do not give them the full report. That only goes to the superintendent. And we keep one on file here.
Yeah, that's the spiking form, isn't it?
Yes, that's the spiking report.
Are there questions? If there are no questions, we'll move on to now those were the 10 policies that had substantial changes, right?
Correct. Yeah.
Okay, so now we'll move on to those who were not in those 10.
So do you want to go?
These just have minor changes.
Correct. And I think almost all of them, the changes were referencing those Title IX policies. Do you want to go policy by policy through these?
That's up to the group. What is your preference? If you've gone over them, maybe not, but if there's something that jumps out at you.
There was nothing that jumped out that was too obvious for any discussion on my part.
Sharonda?
Yes, ma'am, I agree. Nothing specific stands out.
Lane?
I'm good with the proposed changes as is.
Okay. So then we won't need to go over each of them. Is there anything particular, Chris, that you or someone wants to say to us?
I don't believe so. We do have some other folks on the call with us. Do any of you who looked over these policies from your department perspective have anything you'd like to add or clarify with any of them?
I do not.
Okay, then if not, do we have any questions? Does anybody have any questions about any of the policies that we've looked at today? If not, is there a motion that we recommend to the full board the approval of these policies?
So moved.
Was that Lane?
Second.
And Dean? It's
Yes,
been
ma'am.
moved and properly seconded that we recommend to the full board that these policies that we've discussed today, and I won't read, do I need to read all the numbers today? If not, we will recommend to the full board approval of the policies presented today. Is there any discussion? Hearing none, all those in favors, I will call the roll. Lank?
Yes.
Dean?
Yes.
Sharonda?
Yes.
And I vote yes. Opposed? No. Unanimously approved. Is there anything else to claim our attention? If not, then I declare the meeting adjourned.
Madam Chair,
Yes, sir.
Thank you, Ms. Bullock.
Hold
quick
on.
question, it's not pertaining to this.
Okay.
Do these policies have to sit at all, any of them? Or are they ready
they have
for motion?
Do they have to do what?
Sit.
30 days.
Yes, ma'am.
They said for 30 days. There was nothing in here that was suggested that we need to waive that a sitting for 30 days. So these policies will sit for 30 days and then we will approve.
Okay. Thank you, ma'am.
So they're sit for the month of March, and in April they will pass.
Thank you.
You're welcome. If there's nothing more, the meeting is adjourned, and thank you all for your time and your attention.
Thank you.
Thank you, Ms. Bullock.
Thank
Thank
you.
you.
Have a great one.